that they took it out based on my email, and they took out the collage video, and there was probably some miscommunication between the two sides about, again, I never even knew that they were correlated. So I do acknowledge, I do believe what they're saying, and they're saying, well, we kept it out because you objected to it.
Right.
So just like earlier in the trial where I put something in the evidence that had a blank bubble for the date, and then it turned out, well, that was based on rulings. It wasn't me trying to deceive. I just want the truth out at this point. So my suggestion is I'm going to leave it alone on cross, and then the state on redirect, if they don't want me to go into it and create an impression, if that's what they want, I'll leave it alone on cross, and on redirect, they can have Investigator Viverito explain how this came to be and clear it up that it wasn't actually a post that looked like that, but it was part of a bigger post and all that. That's my proposal.
And that's fine, Your Honor. We can bring in, of course, okay. Sorry, we can bring in the video during our redirect of Investigator Viverito, and we'll bring in the entirety of and I want to be clear, Your Honor, this is, I know Mr. Shard is calling it a collage, but it is the Instagram stories that we've referenced multiple times, that these stores are only kept up for 24 hours. And so on the top of the video, you'll see 18 hours, 1 hour. That is how long the posts have been up. And at the time Investigator Viverito screenshotted or video recorded the video, the post would have been within 1 hour of her actual screen grab of the video. So for example, she screen grabbed this video on March 16, 2022 at 9:53:19 p.m. The specific video that we are talking about was posted 1 hour before. So it would have been posted around 8:53:19 p.m. on March 16th.
The story.
The story would have been posted.
Right. Do you have any way to know when the individual pieces of the story were originally posted?
So that is when it would have been posted, because they only run in 24-hour increments. So when it says 1 hour, the post had already only been up for 1 hour when she screen grabbed.
So the whole story, I understand you're saying, was posted within 24 hours of the screen grab. What about the individual pieces of it?
So it tells you. So
do you understand what I'm asking?
I am.
Okay.
Let me share with you, because I think it's better if I show you and then I can describe it for you. Are you able to see this, Your Honor?
Yeah.
So you see right here, Your Honor, it says 18 hours. If I, you can't see it. Okay, at the top, do you see where it says 18 hours? Would you see where it says, bitch, it's lizard?
The white, yeah.
when it says 18H,
Yeah. Uh-huh.
that is 18,
Time to wake up.
that is 18 hours before she screen grabbed it. So here was his video, March 16, 2022.
Right, that had been up for 18 hours in my stories.
In his story. So when you go to the specific post that he is posting,
I've been here through it all. I won't fuck with you often. Baby, I ain't got no reason. I think I need you. Stay down. I done came back from
Council watches all the posts.
Okay. Okay, so back to the charges. I think we were on around page 18, bottom of 18, with parties to a crime. And I'd stated I was going to give it without limiting it to particular crimes. I just want to make sure that we don't have subsection D at all.
are you on knowledge?
I'm on parties to a crime on the page, for me, it's page 18, 19. 1.42.10?
Yes, I don't think we need either.
Okay. Anybody disagree? We don't, D's not applicable? Okay. All right. So the next is 1.42.11. Defense objects to that. You want to voice the reasoning for objecting? Y'all need a minute to get there.
I'm here, I just have some reason
Here.
missing pages.
Look here.
I don't think, the principle failure to prosecute, I don't think that's, applicable to this case. I don't think that it fits the evidence in this case. I don't believe that there's even slight evidence that, the principal has not been prosecuted.
So we've got a, number of different crimes. Including RICO, 2 murders. Let's see. And then I guess gang counts and gun counts for Mr. Stillwell. And then for Mr. Kendrick, RICO, 1 murder count. A gang count, and then several drug counts and a gun count.
I just don't know, in all those cases, I don't know of any principle, the murders, who they're saying were involved, everyone's being prosecuted, as far as, Mr. Kendrick in the house, in Mr. Williams' house, Mr. Williams was prosecuted, so I don't see any.
They don't know that. They don't know what happened to him.
They don't know what ultimately happened to him, but they do know he was charged. And my understanding, the way I read this instruction is just, if a principal is not charged.
Well, that's not what it says. May not have been prosecuted or convicted, may have been convicted of a different crime or degree of crime, is not amenable to justice, or has been acquitted. It's like any of those options.
If it has been prosecuted.
It's not, and all of these have to apply. It's in any of these. And with regard to the Donovan Thomas murder, I mean, who knows what the jury's going to think, but it certainly could be applicable to that.
It could be applicable to RICO count, but can I fill it?
I think it's applicable. I'm going to give it over objection. All right, knowledge. What would this apply to? Because we're supposed to fill in the blank.
Yeah, I don't think we need the knowledge charge. Or we, I should say, the state.
I mean, it kind of seems to pair with parties to a crime.
In RICO, jury believes that, not saying that the evidence has shown this, but I don't know what the jury's gonna, the way that the jury's gonna analyze the evidence, but if the jury believes that if they believe that Mr. Kendrick or Mr. Stillwell, had knowledge of an organization called YSL, but were not actively involved themselves, or not actively doing things in furtherance of the RICO organization, I believe that that would apply.
Okay. Any others besides RICO?
Potentially,
If it's everything, I'll just say the crimes, that the defendants are charged with, but,
for instance, with the murder of Donovan Thomas, they've shown Mr. Kendrick at the Texaco, a video of who they say is Mr. Kendrick at the Texaco. I know it's a lot of debate whether he was actually in the Infinity or not, but I could see it applying there as well. Mr. Kendrick is quote-unquote in the mix at the Texaco, but not actively participating in any crime that happens 5-10 minutes later. And I don't know how the jury is going to analyze Mr. Stillwell on Windsor Street, but obviously he's in the area, and obviously I'm going to be arguing that he was not the shooter. So I think that it would apply there as well.
all right, how about to the drug counts for Mr. Kendrick?
But, yeah, potentially there as well, Your Honor, if there's some theory that Mr. Kendrick had knowledge of the drugs and guns in Mr. Williams' house.
All right, the gun charge, is that based, he's got the one gun charge, right, or does he have two?
Let me look at the indictment again. There are multiple charges related to the guns.
Okay, so he's got
He
the,
has two.
Well,
He has 3 guns.
yeah, he has a bunch of guns. So,
his is based on, okay, the machine gun that's found during the raid, if you will. And then,
there's firearm during commission of a felony in 61.
right, but all of that is if they find that he, was guilty of possession of the machine gun and the drugs, whatever, then he's also,
Right, that's like a foundational thing they have to initially
right.
find.
So I would think it would honestly even kind of apply to that, although I don't know. Like the firearm he's alleged to have possessed is the firearms that are found during the search?
Yes,
Is that right?
That's correct.
All right, so with regard to giving this as to the RICO count, I'm not sure it's an accurate statement of the law for what RICO is, because if you're found guilty, or you can be found guilty of conspiracy to violate RICO, even if you don't know exactly what your co-conspirators might do in furtherance of the RICO conspiracy.
But you do have to intentionally join in on
Yeah,
that
but
conspiracy.
we're going to give specific separate charges about, you have to, about what you have to know to be found guilty of RICO, but it's not, this is not exactly true for RICO.
Not for the individual acts, each individual act.
Right.
I agree with that.
The state agrees as well, Your Honor.
But they're, well,
So I mean, it certainly applies to the murder counts, I would think.
and the guns and the drugs as well, I believe.
And the drugs, the guns, it's really like if they're found guilty of, like for instance with Mr. Kendrick, if he's found guilty of the drugs and the machine gun, then he's also guilty of possession of a firearm by a convicted felon. But if he's not found guilty of either of those things, then he can't be found guilty of possession of a firearm by a convicted felon.
Right, that would be an inconsistent verdict, for sure, if that happened, but, sorry.
Why don't,
Let me see.
for Mr. Kendrick, it's
It's all the weaponry. It's
it's all of the firearms that were in
yeah.
Mr. Williams' house. But is he charged separately with possession of those guns, or it's just that?
Just
Okay,
only
so,
thing charged separately is the machine gun.
okay, so, all right, then I guess if he's found guilty of possessing them, then he's found guilty of possessing them as a convicted felon.
So I'm trying to understand where the court has come out on whether that knowledge instruction applies to the gun and drug charges against Mr. Kendrick from what's at Williams' home.
I mean, there's the whole constructive possession.
Right, there is,
Law.
I understand that, and there's an instruction, I think there's an instruction on that.
There should be. If there's not, we need to put one in.
I believe there is. But there's an intentionality in the constructive
Yeah.
possession as well.
Why don't we put a pin in this one and come back to it? So I don't think it can apply to RICO. I do think it applies to murder. Gangs? I don't
Well,
think it could apply to gangs. They either,
the gang charge against Mr. Kendrick, let me make sure I'm saying this correctly. I believe it's 57. It's count 57. It's based on the
possession
it's
of
based
the
on the drugs
guns
and the
and
guns.
the drugs.
Yes. Everything comes back. Everything is founded on the drugs and the guns, or based upon
Okay,
that.
so, right. I mean, the same for Mr. Stillwell. It's gang activity if he's found guilty of these crimes that would constitute gang predicates. Okay, so we'll just come back to that after we look at the kind of constructive possession charges. Okay. But it'll at least say, at the least, murder. All right, and so part of this knowledge charge includes a parenthetical that, you know, if you weren't knowingly and intentionally committing, participating, or helping in the commission of, or were not a conspirator in, then it would be your duty to acquit the defendant. So the state's certainly alleging that everybody is a conspirator in everything if they are in the RICO conspiracy.
And I think the court asked the question, we need to define it here.
Yeah.
I don't think we need to define
I
it.
think as long as we define it somewhere.
Yes.
Okay. All right, and then mere presence, everybody agrees. Mere association, everybody agrees. Multiple ways of committing a crime. It was requested by the state. Is there any opposition?
Well, we were talking about this on a call on Sunday. As I always understood this charge, it was like for aggravated assault, like two different ways you could commit assault in this charge. I don't know.
We have it here in RICO because we've got RICO subsection A, conspiracy, and RICO subsection B, conspiracy. So I think that's the only place we have it, and so I would think this should come, you know, within the explanation of RICO. Does everybody agree that's the only place it is here? Okay. So we'll give this charge, but it'll be within the RICO. And let's just skip over RICO for now. So we'll have to come back to that. All right. Attempt.
Which page is that, Your Honor?
I'm page 24, 2.01.11. So y'all had mentioned at some point needing to give some sort of a charge on every charge, or, you know, a definition for every charge that is an overt act, but also a crime. Y'all still thinking that? Because I guess that's where attempt would fall.
Yes,
I don't see how else the jury makes the determinations of whether the overt or predicate acts were committed.
All right,
unless they
well,
have
I
the
don't think
definitions.
anybody has submitted what those charges should be, so y'all need to get those put together like today. All right, so attempt will go wherever attempt goes in the explanation of the various overt acts. Okay, down to 2.0210, conspiracy, and then conspiracy additional instructions. Everybody agrees on those. Conduct and presence of the party. Everybody agrees. Okay, criminal gang activity. I have now made some suggestions. Y'all can see where things are rephrased. I don't think we have, on 2.0225, we don't have any allegation that anybody is employed by the alleged gang, right? It's just associated with, so I've stricken through employed by. Everybody okay with that?
Yes, sir.
Yes.
All right, and then instead of everybody okay with commits a crime that constitutes criminal gang activity instead of the mumbo jumbo that is the pattern?
Yeah, I agree with the move to plain English there.
Okay.
Is that the highlighted portion?
So instead of participates in criminal gang activity through the commission of any criminal offense in the state of Georgia or any other state of the United States that constitutes criminal gang activity under OCGA 1615-3, just say, commits a crime that constitutes criminal gang activity, since we're going to define that in a minute anyway. All right, and then next thing we do is criminal gang activity means. The commission, attempted commission, conspiracy to commit, and then there are also possibilities for solicitation, coercion, or intimidation of another to commit. Do we have that solicitation, coercion, or intimidation alleged in this case? Okay, so I'm striking that. And then are y'all all right with the way that it's proposed there to just do kind of bullet points of to prove a violation of subsection A is alleged in 50 and 57?
Yes, Your Honor.
All right, and then element 4 would be a nexus between that crime and the gang. I'm not sure. Most people might know what nexus means, but it's not like a word everybody uses. So I would kind of think it would be more helpful to the jury to include a little bit more than that. So what I did some research and found in 2 cases, Dixon and Rooks, where nexus was explained to be a connection between the crime committed and the gang, which we could say that way, or a nexus, a connection. We could also add that the crime was committed to further the interest of the gang. Now, Mr. Weinstein, I noticed that you had objected to the pattern on that, which, okay, I'm sorry.
I was taking
Mr.
notes
Shart,
for both of us, Your Honor.
the pattern says a nexus between the crime committed and the gang, that the crime was committed to further the interest of the gang, meaning proof that the crime committed was the sort of crime that the gang does. Are you just objecting to that last clause, or also that the crime was committed to further the interest of the gang?
I'm objecting to the last clause.
I couldn't find it anywhere in the case law that that's what it
Okay.
meant, so I agree with you. That should not be pattern.
So we're going to strike was the sort of crime that
Well,
the gang does, Your Honor?
Yeah, so the choice at this point is a nexus between that crime and the gang. I could say a nexus that is a connection between that crime and the gang, or I could just say, or a nexus that is a connection between the crime and the gang. In other words, that the crime was committed, or that the crime was committed to further the interest of the gang. I mean, like, basically any of those, any combination of those, what is the preference of the parties?
Can we write that? So I
It's in front of you. It's on the bottom of page 29. If you have the electronic copy up that Ms. Persfield sent y'all
The language,
yesterday morning.
the language you have now is a nexus, comma, that is a connection, comma, between the crime committed and the gang, i.e. that the crime was committed to further the interests of the gang.
Yeah, that's just some language I pulled from Dixon and Rooks explaining what nexus meant. So I'm just saying we could use any of that and it would be.
That language is acceptable to
Okay,
Mr.
so
Kendrick.
you want me to just say it all?
Just exactly like it's written is
Okay,
fine with Mr.
so
Kendrick.
I'll just bullet point or whatever, element 5 will now be that. All right?
Yes, Your Honor.
yes.
Okay, you got it, Laura. Okay. All right. Definition of participate, I'm kind of thinking, unless somebody on the jury says, what does it mean by participate, that they know what it means by participate. Okay.
Yes.
All right, and then criminals, definition of criminal street gang. Are y'all okay with the strike-throughs? And I can say it all, but
I'm fine with, whatever, state's fine with strike.
okay.
Yeah, I'm okay.
So I would, can you see it on his?
Your Honor, could you tell me the page again?
Page 30, bottom of page 30, definition of criminal street gang.
I think,
Okay, well,
uh,
so
going on?
the
Okay.
criminal street gang means any, this is the pattern, organization, association, or group of 3 or more persons associated in fact, whether formal or informal, which engages in criminal activity. And I'm suggesting that the same concept is conveyed by saying criminal street gang means any group of 3 or more persons associated together, which is engaged in criminal activity, criminal gang activity.
Okay. It's just formatted different on my page,
Okay,
but it's the
sorry.
same thing. No, it's okay, Your Honor. I'm fine with that change.
Can I just make one request?
Yeah.
Which engages in criminal gang activity, which is
Uh,
already been defined for you. Because I don't want the jurors.
Criminal
to
gang
take
activity as defined, have I already defined it by then? Yes.
In 25.
Sure, as defined,
To take a layman's view of what.
as I just defined. Can you stick that in there? All right.
Or maybe as defined in 225 to be more specific. But
No, because
either
they're not
way.
going to have those numbers
Oh,
when they
okay,
get
that's
the
right.
instructions. They won't have the headings. They'll just have the
Thank
law.
you.
And then, it'll continue with the existence of the gang may be established by. And then the pattern suggests, as charged in this case, criminal gang activity is, and then I'm supposed to list the crimes in the indictment that would constitute criminal gang activity, although I would only do the ones that they're alleged. So it would be whatever's set forth in, I guess, 50, 51, and 57, right?
Yes.
So, as charged in this case, criminal gang activity, I think as charged in this case, blank, 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 constitute criminal gang activity.
And then those are going to be, you can say they're defined further down. 'Cause I think you're getting into
So
those
that would be
definitions.
murder, and 57. So it would be murder, and then everything listed in count 57. Possession of marijuana with intent to distribute, possession of codeine with intent to distribute, possession of cocaine, and possession of a firearm during the commission of a felony.
As will be defined for you.
So, question here. Do you want me to say murder charged in counts whatever, or just murder?
No.
Okay. All right. So then that brings us to 2.1010, malice murder. Y'all say you agree, no changes. We've got some parentheticals, rather it's the unlawful intent to kill, and then you're supposed to only put the ones that apply. And the choices are without justification, without excuse, without mitigation. Is there any argument that any of those things has been established, even potentially in the evidence? No. Okay, so it would just end with the unlawful intent to kill, period. All right, premeditation, y'all are in agreement. Motive, agreement. Possession of a firearm during the commission of a felony. Y'all said you're going to tailor it. Let's just tailor it now. Had a firearm on his person or within arm's reach, right?
Yes, Your Honor, we charged it both ways.
While, there aren't any attempts, right, on the firearm things while committing the felonies of a crime against or involving another person, or a crime involving some of the drug stuff, right? None of the rest of them apply?
Yes, Your Honor.
Right.
Okay. And then the drug stuff, as I so aptly put it, would be possession or possession with intent to distribute.
Yes.
I guess the easiest thing to do would be just list those again. Possession of marijuana with intent to distribute. Possession of marijuana or codeine with intent to distribute. Or possession of cocaine.
Yes.
All right.
I'm sorry, could you give me that list again, Your Honor, that you just
So
read
do
off?
y'all want me to say, while committing a felony, which is a crime involving another person or a crime involving possession with intent to distribute or possession of those particular drugs, and then say, I charge you that certain of those drugs are a controlled substance, or just say, just get to the heart of the matter, which is if you find he did these things, then that would be possession of firearm during this type of felony. And then do I need to say, so my question is, do I say while committing a felony, which is a crime involving or against another person, murder is a felony, which I will define, or which I've defined for you, or do I just say while committing the felonies of murder or possession of these drugs?
I think the latter, Your Honor, is cleaner.
It is
Yes,
cleaner.
I think so
It's
too.
simpler.
Everybody agrees?
Yeah, I agree with Ms.
Okay. So yes, it would just say, number 3, while committing the felonies of murder, possession of marijuana with intent to distribute, possession of codeine with intent to distribute, possession of cocaine, or possession of cocaine. And that's it. And then for purpose of this offense, a firearm includes any handgun. Do we have rifle, shotgun, taser, or stun? I know we don't have the rest of them. Do we have rifle involved at all? Do we know?
No.
Not for these two counts.
No, Your Honor.
Okay, so for purpose of this offense, a firearm includes any handgun, period. All right, we don't need, 2.42.00.
Your Honor, we do. Yes, we do, Your Honor.
We need it tailored to 133, right?
No, unfortunately, no, Your Honor. When we, in looking at the indictment, Your Honor, it looks like for count for the two counts, count 63 and count 52. While we did charge 133,
Yeah.
it is missing an element. And
It's missing the indictment is missing an element?
Yes, Your Honor.
That was going to be subject to the motion.
And so we believe that the language as charged is a 131 charge and
So-
not a 132.
What's it missing?
It's missing the crime that they committed while being in possession of the handgun.
So I don't think y'all get a do-over on that right now.
But we believe that the evidence that's established has the elements
I
of
think it
131.
probably has potentially, but you charged 133. So if you get a do-over to do 106 or whatever it is, then you need to give me law that establishes that.
Okay, we'll get you law, Your Honor.
So either it's going to be, in my view, 133 or nothing, unless y'all have law to change my mind. But assuming it's 133, I think it's possessed a firearm after having been convicted of a felony involving the use or possession of a firearm. And then I normally would have put blank as a felony involving the use or possession of a firearm. But we'll just hold off on that one until you come up with whatever law you're going to provide. Okay, possession of a machine gun. And I'm going to write this the same way the rest of them are written for whatever this offense is, and then here are the elements. Y'all dropped the language of the statute in. I'll just use those elements to do the kind of bullet point thing, okay? So it would say something like, the state must prove that the defendant possessed, or it's just possessed, a machine gun during the commission of those crimes. Okay. Tell Laura, just write me a note to rewrite it like the other ones are. Okay. 2.70.10. Y'all agree? So it's for its possession, right, of marijuana or no, it's possession of cocaine, right? Y'all help me out here.
The possession charge is cocaine and 60.
Okay. So it's possession of cocaine. The state must prove that defendant possessed or had under his control cocaine, which is a controlled substance, right?
Correct.
All right, then moving to 2.70.14. For possession with intent to distribute marijuana, the state must prove the defendant possessed with intent to distribute any amount of marijuana. And because it's a separate count, I would then do for possession with intent to distribute a controlled substance, it would say to distribute codeine, which is a controlled substance.
Yes.
And Your Honor, can we, I'm sorry, I was typing, can we go back to possession of machine gun?
Yes.
If you did not say, and I apologize if you did, I think we need to define machine gun, which would be 1611-121.
me see what 1611-121 says. Does it give me a definition of?
Yes, it does, Your Honor.
Well, that's very helpful. And obviously, I'll let y'all look at it again after. We put it together. Okay, so Laura, we can just go and lift that definition from that statute. It's in there. It's 1611-121. It's part of element 1. Yeah. And then definition of marijuana, everybody's good with that. Did we have testimony that whatever was found was marijuana?
I don't believe y'all introduced any of the lab reports, did you?
Detective Storno testified that it was marijuana. Now, there's no lab test, that is correct.
Okay, well, anyway. All right, and then there is 2.76.10, actual and constructive sole and joint possession. Seems that everyone agrees. So we've got parentheticals.
Your Honor, I apologize for not, the GBI analyst who testified about all the pills, she also talked about she tested the marijuana.
Okay. So, state must prove that defendant possessed the marijuana, controlled substance, or gun, right? Or gun at issue in this case.
I'm sorry, could you give that list again, Your Honor?
I mean, I would think it would be the marijuana, I can just say codeine, cocaine, and guns, firearms, because it's a machine gun too, guns.
Yeah, firearms. There's a half a dozen, roughly, so.
Okay, on equal access. I would think it would be the same list of things. Do you want me to read both parentheticals, possess and put those items?
I mean, I'm fine with just possess, Your Honor, but.
All right, well, since it's your client that's facing those charges, although not with the guns, just possess and not put the items where they were found. That's an interesting one.
Well, I just don't believe there's been any evidence introduced of
We're just going to go with possess.
putting. Or possessing, but that's neither here nor there.
Okay, moving down to 276.30, if you find that the defendant owned or leased the, where would,
What's the second
Mr.
paragraph?
Kendricks is all the stuff that was found in Mr. Williams' residence, right?
Correct.
That's what he's charged with.
Yeah.
Mr. Stillwell is charged with what? The stuff that was found in the studio? Yes, no?
No.
What did I say?
Stillwell is,
Is it the reverse of that?
yeah, he's not charged with it.
Isn't he charged with possession of that possession of a firearm is if he committed the murder with a firearm?
Right.
Okay.
Mr. Williams, the thing that seems a little bit confusing about 27630 is it seems to be written from the point of view that one of the defendants is the owner of the residence. I don't know if
It may not even be applicable.
Well, I think it would be. I'll let Mr.
No. I think it would be applicable, but I think it would need to be altered somewhat because it's Mr. Williams that.
Well, I know, but that's better for Mr. Kendrick. If you find Mr. Kendrick owned the residence, well, he didn't. We all know that. Right? So then that part is not, I can read it, or I can just not read that because it's not applicable.
Yeah, okay, now I see what you're saying. Your
We
Honor.
could just say,
Yeah, I've read it. So it probably isn't.
I just wasn't sure if instead of saying that the defendant owned an individual.
if you find that an individual owned or leased the residence
Yeah.
where all of that
guns.
stuff was found, then you may conclude that that individual possessed everything found there. However, if you find that others had access to the residence, then the owner's ownership of the residence is not by itself enough to prove possession. Frankly, the whole thing's just not even applicable here.
Okay. You may.
Okay,
I don't object
so
to it
we
being
won't get
removed.
that one at all. All right, affirmative defenses. The note is, defense believes this must remain. So I need some evidence
Go back.
to,
Mr. Stillwell keeps trying to trip me. So,
So he has no proof of that.
Your Honor, I am taking the stance that, well, again, if there's a directed verdict or if there's some issue with the gun charge, then that solves this problem. This relates solely to the gun charge. We have heard testimony from the gang investigators as well as Investigator Thorpe. Woody's allowed to have a gun. Woody's allowed to have a gun to protect himself. People are shooting at Woody. It's okay if he has a gun. And my stance is that we've heard testimony that people are repeatedly trying to murder Mr. Stillwell. Mr. Stillwell is charged with possession of the FN 5.7, and he's charged with that. And our stance is, while it doesn't, it falls under F for justification, which is in all other instances based on similar reason and justice as those enumerated
and
in this
can you
charge.
give me a second to find where that's his count, what, 52?
52 and 64.
No, he's not even, 52 and 64?
Yes, Your Honor.
Well, 52, 54, that one doesn't chart, that just is the murder. 64.
It really applies, if he's convicted of 52, or whichever the first gun charge is that's associated with the murder, then that clearly wouldn't be, fall under instances of reason and justice. But for 64, when it's a standalone gun, we have laws in place under the jury charge 30110 for justification. And my argument is that the jury charge F is applicable under 30110. Unfortunately, what's complicated is to understand F, you need to.
Hang on just a second. So count 52 charges that on March 14th, he possessed a gun, and that was the Drinks murder, right?
Yes.
Count 64 charges he possessed a gun on the 17th of March,
Yes. And that was on Meadowlark Drive. The
when
gun
he
that
was arrested?
Right, right. The gun that the state is saying was thrown out the car.
Oh, which you've,
Registered to Miss Alexander.
okay.
And my argument is if the jury finds that Mr. Stillwell was in fact carrying that gun around and either he or Mr. Nichols discarded it out the window, 30110F would apply based, and the reason it would apply to him specifically is because we have heard testimony about repeated attempts on his life. Now, the dilemma, if Your Honor were to agree with me about F, the issue is that F is a reference to A through E. So we would have to give them all A through E, but just
Well,
make sure that they understood that I was arguing F.
well, it would only be A. It wouldn't be any of the other ones.
Yeah, you know what? You're right, Your Honor. I'm sorry. You're right. It would just be.
Okay, but here's the thing with the law is that if he had been possessing a gun despite being a convicted felon and somebody came up to his window and held up a gun to his temple and said, you know, dance or I'll shoot you, and he shot them instead, then he might be justified not only in shooting them, but in possessing the gun that would otherwise be illegal for him to possess. He couldn't be charged with that. Well, he could be charged. He couldn't be convicted of that. But here, he didn't do anything that was justified conduct. You know what I'm saying? Because it's a specific reference to 16:3, 21, 23, 24, 25, and 26, which is using a firearm in defense of self, home, others.
My understanding of I think it's a Johnson case. It's the one that the Hogues argued, and was the first one that dealt with the situation that you laid out with possessing a gun and then using it in self-defense, even though you're not. My understanding of that case is that you would have a justification argument for the act, the murder, the shooting, whatever it is, but you could still, unless you grab the gun in a sudden emergency,
Right.
you could still be charged with the gun. The difference that here, from my perspective, is the person in your scenario is just someone who's carrying a gun because they want to carry a gun and they're not supposed to carry a gun. Then something unexpected happens and they use the gun.
Okay,
My
well,
scenario-
he knows somebody's after him.
Right,
Do
that's
you
the
have any
difference.
case law to support your
There's
argument?
no case law I've been able to find.
Making law, huh?
Yes, making law. Someone has to make it.
That's true.
But F exists for a reason.
I don't think there's any law that says that, I mean, especially if Johnson is a case that says if you're a convicted felon, unless you grab a gun in an emergency situation, you're not excused. Your toting it around on your body doesn't excuse you.
For the gun possession. And that is, in fact, what Johnson says, to my
Okay,
understanding.
well, I mean, unfortunately, there is not in the law any exception that says even a convicted felon who knows they have legitimate threats to their life, you know, can go to some government office and say, I've got legitimate threats. Let me carry this gun. That's just not what the law is.
Of course, I'm going with the court, and I respect the court. I would argue that that's what F is. That's why F is there. because it says in all instances based on similar reason and justice. And to me, this is similar to 16, 3, 21, 23, 24 self-defense.
I mean, I like your argument. It's a
Thank
good
you.
legal argument. It's clever. State want to be heard?
That's just, it's frankly not the law. I mean, the law allows us to, we could charge him with possession of a firearm during the commission of a felony or by a convicted felon 3 different times, knowing that he had it before and knowing that he had it after if he left with a gun, but he could be found immune from possessing the gun during the alleged whatever act he was justified in protecting himself with. But you can't just carry a gun around as a convicted felon and not be held accountable for it unless you are found to be justified in using the gun at the time in which you fired it.
All right, I am not going to give that charge. If you want to perfect the record any further, you can go ahead and do that. But I think it's pretty clear what your argument is.
Yes, Your Honor.
All right, so we will not be given 3.01.10.
In that case, and just for the record, I'm not acquiescing. I'm maintaining my argument, but just in all came to the court, then we probably don't need 30000.
Okay, or 31010.
Correct.
All right. And we clearly don't need 31011 because it doesn't even exist anymore.
I don't think we need any of these
All right.
justifications.
I don't either because they all are like basically if they're, so no 1-2 and no 1-3. All right, then venue. Should be indicted and tried in the county in which the crime was committed. I'm going to strike the except as otherwise provided. We don't have that, do we? And then venue for RICO, y'all are both in agreement that the one that's listed is fine?
Yes, Your Honor.
Okay. Venue for conspiracy to commit a crime. Other than RICO, nobody's charged with conspiracy to commit a crime as like a separate offense, are they?
No.
So, do we need this charge? Venue for conspiracy to commit a crime?
We would not seem to.
I don't think so either. Okay. All right, I need verdict forms or suggested verdict forms for 1.60.12, multiple defendants all, and it says adjust. Do we want that at all? What is anyone proposing on that?
I don't want that at all. Because I believe that is, I think that's covered in the next.
I mean, I'm going to tell them determine guilt or innocence of each defendant separately.
I don't believe that this is necessary.
Okay.
And I'm sorry, y'all, which part is not necessary?
1.60.12. Do we need that? It's way too hot in here. The defense is no longer requesting it if they ever did. Is the state still requesting that?
You said 1.60.12, correct?
Yeah.
Multiple defendants.
Right. Given that we're given the charge below about assessing the evidence against each defendant that the state requested. All right, assessing the evidence. It appears the state requested it. The defense is fine with it. And I assume the state still wants it, given that you requested it.
Yes, Your Honor.
Okay. Court has no interest, no sympathy. Sentencing, responsibility for, state questions why I don't want to give that. Because if I'm telling the jury, don't concern yourselves with punishment, then why am I telling the jury anything about punishment? It's like, don't think about an elephant.
Because
It also seems to suggest that there's likely to be a conviction
well,
coming from the court.
I think because human nature, people will think we don't instruct them that they're not charged with what happens after the guilt innocent phase. And I think that's why this jury charge is important, because they may, in my experience, sometimes think about sentencing and think about what happens after this point, and am I responsible for that? So I believe letting
So if
them
they
know-
ask us that, then we'll say, don't concern yourselves with that.
I think innately, especially with a count like murder, where people know what the penalty is, that's typically what the request.
People think they know what the penalty is.
Right, but I guess because the people think they may know what the sentencing range is and what the penalty is, which is a life sentence, a lot of times that can come into how they view the evidence and things of that nature, and how it can be a factor in their decision making, which is why we request it.
To me, that's covered in sympathy. They're not supposed to have sympathy towards.
Okay, well, I don't ever give it, and I'm not giving it here. If they're not supposed to think about it, then I'm not raising that for them to then think about. All right, and nobody has any issue with deliberations or unanimous verdict. State, there's a note, state will be adding additional charge on consciousness of guilt flight. Do y'all have that ready?
It's not permissible.
Okay, well, we'll need to get that.
We're not.
Oh, you're not going to do it, okay,
It can be argued, but it can't.
okay.
Of course, not to do a charge on it unless the defense requests it.
All right, so jumping back up to wherever knowledge was. I don't know where it was. I think it might have been before the RICO charges.
Page 19.
Yeah, page
Thank you.
14310 on 19.
Okay, thank you. All right, so it seems that the knowledge that would be necessary for the drugs and the guns is explained within those kind of possession charges. Do y'all agree? Or what do y'all think? Anyone?
Our preference would still be to keep that knowledge charge in, especially, I understand that
I'm asking which crimes do I say it applies to?
the murder, the drugs, and the guns. Did I leave anything out?
I think D, all of the above.
No, I left out the RICO.
And, the RICO.
And the gang, which.
Well, the gang is,
It wouldn't even make sense for the gang.
no, so the murder, the drugs, and the
Okay,
gun.
so
genre.
knowledge on the part of the defendant that the crime of murder, I mean, I think it might be appropriate here to say murder in count whatever, possession of whatever it was, drugs in count whatever. Do y'all think? Was being committed, and that the defendant knowingly and intentionally participated must be proved by the state beyond a reasonable doubt. If you find that they had no evidence that the above listed crimes were being committed, or that the defendant did not knowingly and intentionally participate or help in the commission of the alleged offense, I don't think we need conspirator there, because conspirator gets covered in the RICO.
Yeah, we don't need that.
Okay. On the other hand, should you find beyond a reasonable doubt that the defendant had knowledge that the crime of, list them again, and that the defendant knowingly helped or participated, then you would be authorized to convict the defendant of that count, I'm going to add that.
Yes.
Okay.
Thank you.
All right, anything else we said we were coming back to? Obviously RICO, but anything else?
I sent a proposed charge to Ms. Percifield and counsel as it relates to count 51. Mr. Stillwell is charged with 1615-4 subsection B. And I sent a proposed charge as it relates to that count. It's not covered by the pattern.
That being gang?
So the pattern covers 1615-4A. It doesn't cover B.
Isn't that in our gang? It's, if you look at what's there.
It's already in there.
I'm sorry.
I did, where is it? Yeah, there's, to prove a violation of subsection A of the Gang Act as alleged in counts 50 and 57, the state must show blah. To prove a violation of subsection B of the Gang Act as alleged in count 51, the state must show it's all of those plus, in order to, there's an additional element, number 4, in order to maintain or increase his status or position in the gang.
I'm sorry, Judge.
This covers that, right?
I completely
Okay, it's okay. All right, anything else?
Could I have 5 minutes before you bring the jury out, Your Honor?
Yes.
Thank
I mean,
you.
we've got, oh, right. We told them 10. Do we know whether they're all here? They're not all here anyway. So yes, you can have until they get here.
Thank you.
We can go ahead and get the jury in. Thank you. Good morning. I gave Paul that mic that's got the red on. Was those glasses? Black. Those glasses. Yeah. Thank you. Everybody can be seated. Go ahead, Mr. Sharp.
Thank you, Your Honor. May it please the court. Good morning. Good morning.
Good morning.
Investigator Viverito.
Good morning.
Are both those mics being used?
This one is.
Oh, it's fixed.
Yeah.
Okay. All right. Thank you. So, Investigator Viverito, where we left off yesterday, we were talking about a post that was captured by you that showed Quamarvius Nichols with some writing on the picture, correct?
Correct.
Okay. We are going to get back to that later.
Sure.
Okay. So we're going to switch to another topic right now. But it is about the posts from March 2022 that you collected.
Okay.
Okay. The reality is, in March 2022, you observed and collected some posts that you felt were relevant
Sure.
and that you felt were derogatory or mocking both the Christian McMiller and Darius Ford situation.
I'd have to see which posts were.
Well, we're going to get to individual
Okay.
posts, but some of the posts were derogatory and mocking Christian McMiller and Darius Ford.
Correct.
And then you also pulled posts that you thought were derogatory or referencing or mocking Shamel Drinks' death. Is
Correct.
that correct? Okay. And let's be clear. As an investigator, you are not saying just because someone posts something derogatory or mocking or referencing the death of another individual, that means that they committed that crime. You are not saying that, are you?
That is correct.
Okay. And I just want to talk to you about a couple of these posts. I'm going to bring them up to you, okay? These are all this is a bundle of the posts that you collected that are in evidence, correct?
Sure.
All right, may I approach?
Yes.
For instance, you observed some posts that were made following the Christian McMiller Darius Ford double homicide
Correct.
on March 10th going into March 11th. And these posts were in the days following.
Correct.
Okay. Ms. Knight, could you do me a favor and publish what's been admitted as 457 VV? Investigator Viverito, this is a post posted by one ABG_Big Nick, correct?
Correct.
And you know this person from the picture and also from his name on Instagram to be Nicholas Johnson.
Correct.
Okay. And in this post, when was this post collected by you?
That was collected, would have been around 8:20 on March 11th.
March 11th. Okay. So this is the morning after Christian McMiller and Darius Ford were gunned down.
The evening, 8:20 p.m.
Oh, I'm sorry. Okay, the evening after.
Correct.
About 20 hours after, 21 hours, or 19 hours after.
Somewhere around there.
Okay. And this post includes a, says slime and chalk.
Correct.
Okay. And you viewed this as a clear reference to Darius Ford and Christian McMiller being murdered in reference to a chalk outline of a body on the street.
Correct. Coupled with my knowledge and interactions with Mr. Johnson in the past, yes.
Right. I think you testified that Mr. Johnson, in your opinion, he is associated with Atlanta Blood Gang.
He's documented as a member, and he's also a fixture at 12 Atlanta Daily.
Okay. So you saw this post, posted the next day, referencing the death, mocking slime and chalk. Mr. Johnson has not been charged for the murders of Christian McMiller and Darius Ford, correct?
Correct.
And the reason he hasn't been charged is because posting something like this, while it is insensitive, while it may be wrong, it doesn't mean that he killed Christian McMiller and Darius Ford, does it?
Correct. There's other things we would look at, like if he was in the vicinity of the murder on camera, coupled with a post that's not great, that would be something we'd take into consideration, but that didn't happen.
And Investigator Viverito, I knew you were going to be dying to say that, and we are going to talk about all the surveillance videos and all of the situation involving Mr. Drinks when I get to it, okay? But I'm asking you specifically about posts. Posts that is not a confession to killing Darius Ford or Christian McMiller, is it?
Absolutely not. But as an investigator, you need to look at things as a whole to piece things together, leading you towards suspects.
Okay,
So,
and that's why you collected this?
correct.
Okay. Ms. Knight, I'm going to ask you to publish 462 VV. Okay. 462 VV is two posts that showed up on this page labeled Joey_Hurst24, correct?
Correct.
All right, and on the left is Christian McMiller,
Correct.
and on the right is Darius Ford.
Correct.
And they're fairly self-explanatory. They're mocking the death of Mr. McMiller and Mr. Ford, correct?
Correct.
All right, and this was posted when?
I'd have to see the file name.
Okay, so you're not, and that's fine. Was it posted after the death of Christian McMiller and Darius Ford?
Yes.
Okay. Now, I understand your belief is that this is a trolling page or a fake page. Is that correct?
It's a page, yes, it's a page that we had not seen surface really or be vocal until this point.
Now, and certainly when you see a page like this, there are certain investigative things that you could do to try to determine who is behind this page, correct?
Correct.
You could subpoena Instagram, you could check IP addresses to see who set up the page, etc.
You could.
Okay. You or anyone else that you know of did no such thing to try to determine who Joey Hurst was?
No.
The government name. Okay. And the reason you didn't, and I'm not trying to beat you up, the reason you didn't go through those steps, if you thought this was a confession, and you thought this meant that Joey Hurst killed Mr. McMiller and Mr. Ford, you certainly would have gone through those steps to uncover who it is behind this post, if you thought that was the killer.
If I thought that was, but the investigation led us to other suspects.
Okay. The bottom line is, you did not view these posts as signifying that whoever was behind this account was the killer of Mr. McMiller and Mr. Ford. You didn't view it that way.
Correct. The individuals that were making posts who we deemed as suspects, they were further investigated, whether it be cell phone extractions or social media.
Okay. 456 VV. Please, Ms. Knight. Thank you. Okay, and this post was collected on March 11th, 2022 at 11:30 p.m., correct?
Correct?
Okay, so again, about a day after Mr. McMiller and Mr. Ford were killed.
Correct.
Okay, and you testified on direct about what you thought. New op pack just came in. It's kind of like we're smoking on our ops.
Correct.
Okay. Certainly not kind, not nice, not sympathetic, and it's showing approval for what happened, correct?
Correct.
Okay. And this page is another one that you didn't know the government name of the person behind it.
Correct.
Okay, and you didn't go through any investigative steps, or anyone else that you know of go through any investigative steps to determine the person behind it.
Correct.
Okay, and the reason, again, is because this post, you didn't take it as a confession. You didn't take this post as saying, I'm the person who did it.
Correct.
Okay, cool. Finally, we're going to talk about Kelvin Watts.
Okay.
Okay, Kelvin Watts has not been arrested for the Christian McMiller or Darius Ford murder, has he?
He has not.
Okay. And this has all happened 2 years ago at
Correct.
this point. Okay. Really 2.5 years ago, more than 2.5 years ago. Mr. Watts made several posts regarding the death of Darius Ford and Christian McMiller.
Correct.
Okay. Ms. Knight, could you please publish 473 VV for me? Okay. In 473 VV, that's posted by Shell Kell Nutlife, correct?
Correct.
And you know that to be Kelvin Watts.
Correct.
And this was posted shortly after the death of Christian McMiller and Darius Ford?
Correct.
Okay, and this actually depicts Mr. Donovan Thomas.
Correct.
And underneath Mr. Thomas's left eye are 2 shells.
Correct.
Okay, and as an investigator, you're aware of like prison tattoos or eye teardrops under an eye, correct?
Yes, that's what I spoke about on direct.
Okay, right. And you took this as kind of a play on the teardrops under the eyes of 2 shells indicating 2 bodies, Darius Ford and Christian McMiller.
Correct. The first time we started seeing the 2 shells under the eye was after the death of Christian Ford and Darius McMiller, I think in days following.
Okay, Ms. Knight, could you please publish 461 VV? And here's another picture of Shell Kell or Kelvin Watts that posted shortly after the death of Christian McMiller and Darius Ford, correct?
Correct?
Okay, and these are, you got to look a little close, but I see the big shell off of his hair, but then there's two little shells under his left eye.
Correct?
Okay, and again, that's a post that you interpreted to be a reference to the death of Christian McMiller and Darius Ford.
Correct?
Okay. Ms. Knight, if you could publish 454 VV, please. Okay, in this post, again, shortly after the death of Christian McMiller and Darius Ford, correct?
This was in the hours after they were killed, yes.
And this is on Kelvin Watts' page.
Yes.
And again, we see the two shells,
Correct?
okay, and that had significance to you because there was two dead bodies.
Correct.
Okay, thank you. And 460 VV, please, Ms. Knight. Okay, again, here, this was posted shortly after the death of Christian McMiller and Darius Ford.
Correct?
And we have two shells, right?
Correct?
And we have a smiley face, except the lips are zip tied or zipped up, I guess,
Correct?
and a black heart.
Correct?
Okay, and this was on Mr. Kelvin Watts' page.
Correct?
All right. Also, and Ms. Knight, thank you. Also, you're aware that Kelvin Watts has made a song that references Christian McMiller and Darius Ford, correct?
He may have.
You never heard Mafia Story by Shell Kel and Third World?
I haven't, but it would not surprise me if he did.
I heard my ops died like some thoughts, referring to two snakes dying with their eyes wide open and their tongues out. Crime scene nasty in a fast car, died in empty traffic.
That sounds about on brand for Kelvin Watts.
Okay, and that was a reference to the Kia Stinger, the fast car is Kia Stinger that Mr. McMiller and Mr. Ford were in.
That sounds about right.
Speculation.
Were Mr. McMiller and Mr. Ford riding in a Kia Stinger?
They were in a gray and color Kia Stinger.
Okay, and were they in fact shot on the highway?
Yes, they were on the highway.
Okay. Mr. Watts, despite these 4 posts that you collected and this song, has not been charged with the murder of Christian McMiller or Darius Ford, has he?
No, he has not, but that's also an open investigation that's not assigned to me.
Okay, that's fine.
But
So, but the answer is he has
He
not
has
been
not.
charged. And it's just 2 years, 8 months later.
it's still open active investigation.
Right, and you've had you collected these postings that Mr. Watts made way back in March of 2022.
Correct, but so investigations, just the social media posts aren't enough to arrive at probable cause. You'd need him maybe on video at the crime scene, before that murder, things of that nature. So if social media was enough for probable cause, a lot of people probably would have gone to jail for this, but we don't do that.
Right, because there were a lot of people posting on social media.
Correct.
A lot of people posting horrible things on social media.
But unfortunately, nobody was on camera at the scene, or there was no Nibin.
Investigative Viverito, I know that you have come with an agenda today, and I know that you want to talk about the security cameras, and we will absolutely talk about the security cameras, I promise you.
Commentary and
Well, there's commentary going on both sides. Answer the question that's asked.
Okay, I want to clean up some, we're going to shift off of social media and we're going to get to the wiretaps. Okay, I want to clear up some issues, or not issues. I want to talk about the wiretaps and what we talked about Friday and yesterday. You had a wiretap. I understand you had one on Mr. Sumlin's phone. I'm not going to be talking about Mr. Sumlin's phone. I'm talking about Demekion Garlington. Okay?
Okay.
All right. Do you have the number for the total number of calls recorded or listened to during that wiretap?
I don't know off the top of my head.
Okay. Was it in the thousands? Is that fair to
Probably
say?
in the thousands, yes.
Okay. Do you know how many total calls Mr. Stillwell was a party to?
I couldn't give you a number, but it would probably be not as many as others because he went into custody, I think, within 6 days of the wire going up.
Fair enough. And just so we're clear, when you apply for a wiretap, you send something to the phone company, correct?
Correct.
And the phone company is told not to inform anyone about the wiretap, certainly not to inform the subscriber.
Correct.
So no one, to your knowledge, no one told Mr. Garlington that he's being recorded,
Correct.
okay, because that would defeat the purpose of the wiretap,
Correct.
right? And to your knowledge, no one told anyone else that there was a wiretap on Mr. Garlington's phone.
Correct.
Okay. Now, the state referred to the calls that were played for the jury yesterday as a sampling. What was played to the jury wasn't exactly a random sampling of the calls, was it?
No, all of the calls were turned over, and it's my understanding that they had to be narrowed down.
Right. The state, in preparation of your testimony, they gave you a CD or some sort of flash drive with a number of calls that they chose and asked you to review them, correct? So you could speak intelligently about them.
Yes.
Okay. So it wasn't a random sampling. It was calls that the state chose to focus on.
It's my understanding that the prosecution and defense decided on what could and would be played. So it wasn't just random, let me pick 20 calls out of a bag. It was calls that were relevant to the case.
Right. Yeah, right. I'm just saying it just wasn't some random sampling.
Correct.
It was focused.
Correct.
Okay. And so let's talk about some of the calls. We're going to talk about specific calls in a minute, but if you go back to what was played yesterday on that wiretap of Mr. Garlington's phone, there were calls, repeated calls about keeping Miles Farley, who's a small man, right? He is a small gentleman, physically small.
Small, yes.
Okay. Talk about keeping Miles Farley from being violated or attacked at the Rice Street Jail, right? We heard several calls about Miles Farley and keeping him safe.
Correct.
Okay. We heard call, and do you have the call logs in front of you or anything?
I do not.
Okay. When you were testifying yesterday, what were you using to keep track of what calls which?
I didn't have anything in front of me.
Okay. Well, we heard call 2532 from April 3rd, 2534 from April 3rd, 2628 from April 4th, 3501 from April 13th, and 3697 from April 14th, all about Miles Farley and being in jail. Do you remember those 5 calls?
I do.
Okay. Was Shannon Stillwell a party to any of those calls?
He was not.
Okay. We also heard a call 3683 from April 14th about, and you could probably tell me who the people were. It was Demekion Garlington and someone about flying a drone into the jail, it seemed.
Correct.
Okay. Was Shannon Stillwell a party to that call?
He was not.
Okay. Then we also heard about Demekion Garlington going on and on about running into someone named Blizzy at some hotel in Cobb County.
Correct.
Okay. To your understanding, was Shannon Stillwell present for any of those events in Cobb County?
No, I believe he was in custody.
He was in custody. So he wasn't involved with any of those things that Demekian was talking about running the Blizzy in Cobb County.
Correct.
All right. And then we also heard a call between, I believe, Demekian Garlington and Antonio Sumlin, and it sounded, and this was call 3171 and 3172 from April 9th, about seeing someone wearing some jewelry, and they were asking if you have a slider car with paper tags. It sounded like they were trying to come up with a way to commit a crime, a robbery, right?
Correct.
Okay. Was Shannon a party to that call?
No.
Okay. And Shannon was in jail at that time, correct?
Correct.
Okay, so he was not involved in that situation at all either, correct? All right, cool. All right. I'm going to talk to you about specific calls that have already been played. March 14th, 2022 at 9:59 p.m. It's call 335, okay? It's a call where you testified, I believe, and correct me if I'm wrong, it was a call between Demekian Garlington and a gentleman named DeMarco Boyer.
That is correct.
Okay, and that's at 9:59 p.m.
Correct.
Do you know how many, 9:59 and how many seconds? Are you aware of that?
I would have to look at the log for the seconds.
Okay. And in that call, Garlington instructs Boyer to switch to video.
Correct.
Okay. Now, based on your investigation, you said Boyer was at the gas station.
Correct.
And you also said, well, you were about to say, and then I cut you off. Boyer, your investigation has concluded that Boyer was in Mr. Nichols' car.
Correct.
Okay, so, and you're basing that on your investigation. You're also basing it on the fact that Miles Farley, in that video, when he goes back to the car, gets into the back seat at the BP.
That, and there are calls from the wire that
Okay.
say that he's in the car, yes.
Fair. So this call at 9:59 between Garlington and Boyer, your investigation is Garlington, this is your investigation, is Garlington is in Mr. Stillwell's rented white Audi.
Correct.
And Mr. Boyer, who's not charged in
Correct.
this case, is a passenger in Mr. Nichols' Ford Fusion.
Correct.
Okay. White Ford Fusion.
Correct.
Okay. Your investigation, based on the time on the surveillance video from the FedEx surveillance, is that the shooting happened around 10:01 p.m., correct?
I don't know if it's based on the time on the FedEx video.
Okay, well, what's your understanding of when the shooting occurred? If you know.
I don't know how they arrived at 10:02, but I know that's when both cars pull off. Shortly thereafter, within probably a minute or two, the cars pull off from the gas station.
Okay. Now, what I want to know is, it's a matter of timing. The 9:59 and however many seconds that this call is made, where eventually Garlington tells Boyer to go to video, that 9:59 and however many seconds is based on the clock used during your wiretap. That's where we get that time,
Correct.
right? Okay, so that's based on the wiretap time. Okay. So, and then of course, after they hang up, then do you know if there was a subsequent video or FaceTime call?
I believe you could see the data transmission come through.
Okay, and do you know how long that call was, or when exactly when it took place?
Immediately after, but I would have to look at the log.
Okay. And my question is, we have three different sets of time here. We have the wiretap time,
Correct?
we have the FedEx video time,
Correct?
and we have a BP video time.
Correct.
Okay. Are any of those, to your knowledge, are any of those 3 separate surveillance systems synced up?
They're not. So typically what you would have to do is go back and sync them, because I know the wiretap is a constant. I know that's an accurate time.
Okay, so you know, and that's fine. So you know the wiretap is an accurate time, but we don't know if the FedEx is an accurate time or the BP is an accurate time.
I'd have to look at the timestamps on both.
Okay, so I guess what I'm getting at is we can't just go by the BP time and go to 9:59 and however many seconds and say, oh, that's when that call was placed.
I went off of the wiretap data.
Right, exactly.
Correct.
Right, and that's what you were in charge of the wiretap. You went, but I'm going to go back to my question, and that makes complete sense to me that you went off the wiretap time. But we cannot go back to the BP and look at the BP at 9:59 and however many seconds and say that's when his call was made, because those 2 timing systems between the wiretap and the surveillance might not be synced up.
Correct. I'm not sure if they were or they weren't, but typically that's something I double check.
Okay, and the same thing for the FedEx. We can't look at the FedEx time and just go to 9:59 and however many seconds and say, oh, this is the exact time when that call was between Mr. Garlington and Mr. Boyer, between those 2 cars was made. We can't do that, can we?
Correct. I go with what I know to be constant.
Gotcha. So all you're saying is 9:59 on the wiretap time.
Correct.
Awesome. Okay. Mr. Atkins or Ms. Knight, and I should ask you, could you please publish what you played yesterday at call 350? I'm going to ask some questions first. Thank you. So, yeah, I'm going to give you a couple minutes. All right, I'm going to talk really slow because I got to give Mr. Atkins a couple minutes. Okay. So, we listened to another call at 2:01 a.m. between, do you know who that call was between?
I'd have to hear it.
Okay, well, I'm going to cut to the chase. You said in court that you heard someone say, riding by the scene.
I don't know if I said that verbatim, but they're riding back through, I think is the direct quote.
And you said the scene.
They may have been riding back through the scene.
Okay, well, do you now know what call I'm talking about?
I know which call you're referring to, yes.
All right, and if you, and do you know who the speakers were?
Well, if it's from the wiretap, one would have been in Garlington.
Right.
And then I believe the other one may have been Boyer. I have to hear the call. I don't want to misspeak on it.
Okay, and people were fussing with each other. Someone was fussing with someone about not having a ride to get back to where they needed to go is essentially the gist of the call, correct?
Correct.
All right. Now, if you could play, if you could publish.
This is 350.
Right, and whatever, yes, if you could just publish, and I'm going to stop after about 40 seconds.
Bro, who that was? The nigga Ray got in that damn shit.
Okay, could you pause it?
Oh, for real?
All right, now, Miss Investigator Riverito, where do you know who the speakers are?
I believe it's Boyer, but I need to hear a little bit more. That was kind of muffled.
That's fair. All right, Miss Hilton, if you could. Yep.
Yeah, RP, the YP Ray. Yeah, I don't even know him. That who got his change? That who changed Lil J5 to Jason? Oh, for real? Yeah, the YP Ray nigga. Oh, I ain't even know that. Yeah, that little PLK nigga. Oh yeah, I had Lil J5 with me last night. That's probably what it was. I put him on. Okay. Yeah, that who changed it. Oh damn! What I say? Yeah. Buddy came and followed me. I followed his ass back. Hey, talking about fuck around with him. What you talking about? I'm trying to get the other care data address right quick and care address. He testing the young crew. Somebody he finna send a bit.
For real?
Somebody he gonna send a bit somewhere late where the spot at.
Okay.
Yeah.
He told LJ you got liquor left.
20 seconds. And my notes might be wrong, but I don't think they are. Yeah. 20 seconds, please. Could you just tell me when you hear anything about the scene?
Okay, go
Oh,
ahead.
for real?
Yeah, the YP Ray nigga.
Oh, I ain't even know that.
Yeah, that little PLK nigga.
Oh, yeah. I had a J5 with me last night. That's probably what it was. I put him
Yeah.
on.
Yeah, that was
J5.
Oh, no. I'm sorry. Yep. Okay, I'm sorry. You're going by the different number. It's 2:01 a.m.
It's patient 57.
Right. It's the the call 350. All right, here we go. This is the one I meant to pull up for you, Investigator Viverito.
Yo.
All right, man. There was all kinds of shit going on. I just jumped in the other car, bro. Y'all niggas don't be getting dropped off and they ain't got no motherfucking ride to go back home to. That don't make sense.
Yeah.
It's supposed to be getting dropped off for a nigga ride with a nigga who wrote you.
Yeah.
That's stupid as fuck. So, Andy, you need to be on the dumb ass, y'all. What the hell? What's wrong with you?
We right here down here.
Y'all what?
Ride past trying to see.
Okay, stop. Did you not just hear him say riding past through the city?
He said riding past trying to see.
Well, where's the scene?
I said,
You said scene before, now you're saying trying to see, and I'm saying city.
you may have misunderstood what I was saying. You got to understand when these calls come in, when you click on the call, it will also provide a map of where they are, and the next call may show where they traveled to after that. It's my understanding that he traveled back towards that area.
Okay, but towards the area, you mean the city? It's in the city,
They never
right?
left the city.
Okay. Investigator Viverito, you previously testified that he said going to the scene, and now you're saying to this jury that he didn't say scene, he said see. Is that correct?
I don't know if I said he said, I don't believe I said he said he's riding through the scene. He may have rode back. I believe he was traveling back towards the scene.
And I know you're an expert, but if the jury listens to this and hears city, is that okay with you?
But that's not what's said, so I would clarify for them.
I understand that you want to tell everyone what's said here, but you've already given two different stories. You said scene, and then you said
What's your
see.
objection?
Argumentative. in the-
Overruled.
It's,
Can we just go by what we hear? Is that okay?
sure.
Thank you. Okay, call 416, and I don't need this published. Thank y'all. It's from the early morning hours of March 16th, 2022. Okay, there was actually two calls that were played. Do you recall?
Correct.
Okay, one is Mr. Garlington and someone that you say is my client, and the person's whispering. I'm not even going to dispute it, okay?
Okay.
We'll just say it's my client.
Okay.
Whispering about hiding in the crawl space.
Correct.
Okay. And then the second call is Mr. Garlington and my client talking about what just happened.
Correct.
And of course, what just happened was the house was shot up, and then a bunch of police officers showed up, and no one was arrested.
Correct.
Right. Okay. So, and that was the same day, of course, that you spoke to Shannon Stillwell. You put him in the back of the police car, or someone put him in the back of the police car, and you spoke to him, and he told you he was, in fact, driving the white Audi.
Correct.
All right. So, that call, let's just review some things that were discussed by Mr. Garlington and Mr. Stillwell. They talked about their amazement about not being hit by any of the bullets that were fired into 2830 Waters Road, correct?
Correct.
They talked about their amazement that the police let them go from that location.
Correct.
They talked about how they hid from the police.
Correct.
Mr. Stillwell talked about being placed in the police car.
Correct.
Mr. Stillwell said that he denied knowing McMain when asked and said he was from Thomasville.
Correct.
Okay. That was misleading, right?
Correct.
Because he does, in fact, know McMain.
He does.
All right. And McMain, just so we're clear, is Christian McMillan.
He is.
Yeah. And he talks about getting out of there as soon as possible. Like speeding away because he couldn't believe that y'all, the police, let him go.
He does, but he says prior to leaving, he collected his FN and his rifle or stick and he left.
I'm going to get there. Okay. And they talked about seeing you too, right?
They did.
All right. So let's talk about, I know he, in that call, and clearly I'm getting there, he talked about sneaking his FN away from the scene, right?
Correct.
And about sneaking his stick out of one of the cars. I think the gray car.
Correct.
All right. Okay. Now, the FN, you've testified, you know that an FN 57 is registered in Miss Taisha Alexander's name, correct?
Yes.
Okay, and that gun was located at Meadowlark Drive on March 17, 2022.
Correct.
Correct? The next day after this call.
Correct.
All right. Does that FN shoot .40 caliber bullets?
Does not.
That could not have been the murder weapon for Shamel Drinks.
No.
Could it? Okay. He talks about taking a stick from a car on the scene, right?
Correct.
And you know the stick to be an AK-47 type assault rifle, correct?
Could be an AK-47. It could be an AR-15. It could be, it's a rifle.
Typically shoot 7.62 caliber bullets.
Correct.
Okay, not 40 caliber.
Nope.
Okay, so you would know that that stick that he talks about taking from the scene once you guys let him go is, in fact, not the weapon used to shoot Mr. Drinks.
Correct.
All right. And in this call, where, again, you don't have any reason to believe Mr. Stillwell knew he was being recorded.
Correct.
Or Mr. Garlington knew he was being recorded. In this call, he never talks about taking any other guns from the scene.
Correct.
Okay. Okay. Call 2119 is another call that was played. It's from April 1st, 2022 at 12:29 a.m. It was a call between Demekion Garlington, who's on the wiretap, and Shannon Stillwell, who's in jail at this point, correct?
Correct.
Okay. And Demekion is on his normal phone, and you testified that Shannon Stillwell, when you're in the jail, you said there's wall phones, right?
Correct.
Okay, and that's, the jury has heard those recordings where they talk about Securus, and this phone will be recorded, and they are in fact recorded.
Correct.
Okay. Mr. Stillwell was not on a recorded line.
Correct.
He was on a cell phone from the jail.
Correct.
Okay, so he, in common sense, he doesn't know that Demekion Garlington is being wiretapped.
Correct.
Okay, and he has no reason to believe that the cell phone he's using from the jail is being recorded.
Correct.
It's fair to say that they believe that they're having a private communication that is not being recorded.
Correct.
All right. Mr. Atkins, could you do me a favor? This call, 2119, and I'm talking about at 12:29 a.m., could you play on April 1st, 12:29 a.m.? Your Honor, may I consult with the?
Yes.
$240 to $315 is what I want. And we're just going to cue that call up, okay? And I'm going to ask you some questions about it.
Sure.
Thank you, Mr. Atkins. And if you could cue it up to 2 minutes and 40 seconds. $240.
I'm telling folks, bro. I'm like, shit, what the hell they locked up for? Like, they just saying about the camera. I'm like, bro, they good. I'm just like, they gonna assume some shit like that anyway. You feel me? They gonna assume that, like, oh, like, y'all ain't did nothing, you feel me? So,
That's what I keep telling Lil, I keep telling him, like, just chill. Like, I know,
yeah, cause they
this
saying he
ain't
panicked.
nothing. Yeah, I'm like, this ain't nothing, bro. Like, they just doing that cut. They seen as a goddamn gas station. Like, just chill. You see what I'm saying?
Yeah. Hell yeah, man. That's what I'm telling. I keep telling him all the time. Shit. I'm like, listen, bro. Just like you, like, bro. I'm telling probably in the cat. Listen, bro. No, just tell him before you want to talk, bro. Like,
Not one word.
yeah.
Go down on what they try to portray or what they say, man. Don't say shit.
Hell yeah. I ain't know that though, but so I didn't have my, I didn't have.
And you can keep that up because I'm going to ask you to play another part. But thank you, Mr. Atkins. So on that call, again, neither party has reason to believe they're being recorded. That's Demekion Garlington and Shannon Stilwell.
Correct.
And they talk about they going to assume shit.
Correct.
Mr. Garlington says, y'all didn't do nothing.
Correct.
And then Mr. Stilwell says, they just saying it because they seen us at the gas station.
Correct.
Okay. Mr. Atkins, if you could please play 11:20 at 11:28.
Yeah, man. What the hell swimming on? You still in yo?
Yeah. Okay, what is that?
You know what I'm
Yeah, see.
Who?
Who?
Yo, folk.
Yeah. Okay, what is that?
we're going to come back to that one because I want to get the timing right.
Okay.
What's that?
Okay.
Okay. And that is, Mr. Copeland. You go first. Okay. And we're going to come back to that call. But let's talk about Mr. Stillwell's phone that was collected.
Sure.
Okay. Do you know you're able to view? So you collect the phones. Detective Leon Packer, he dumps the phones, and then you're able to view the phones, the contents of the phones through a program called, what's it called, XRZ, is that correct?
XRY.
XRY, okay. And you get just a whole bunch of information that's in whoever's phone. Pictures.
The contents of the phone are organized by category.
Right, and we're talking about pictures, text, emails, instant message, call logs, location, data, internet searches.
Correct.
Notes.
Correct.
Okay. And if you don't know, that's fine, but do you know how many texts or calls total were in this phone?
I don't know off the top of my head, but it would be listed on the extraction, on the front page of the extraction. When you open it up digitally, it'll give you what you're going to see initially is it's everything by category. So it'll say 20,000 texts, 100 calls, things of that nature.
Okay. Ms. Knight, if you would please display 227 VVA2. Oh, Ms. Knight, sorry. VVA2. Yes. VVA2. 227 VVA2. Thank you. A. Okay, this is one of the text messages or one of the text conversations that was introduced on Friday, I believe. Correct?
Correct.
Okay, and this is from Mr. Stillwell's phone.
Correct.
All right, and in his phone, Mr. Stillwell's talking to, is that D? Do you know that number to be Demekion Garlington?
I believe so, yes.
Okay. Because there's a couple of D's in this case, but you believe this to be Demekion Garlington?
He did change his number right before the wiretap, so I believe that's the number before.
Okay. And if you could zoom out a little bit, Ms. Hilton. Oh, Mr. Atkins, so we can see the whole conversation. Thank you. Thank you, Mr. Atkins. So, in this conversation, to add context, Mr. Stillwell is indicating that one of his two phones is at Big House.
Correct.
Okay. Do you take that to be Darius Ford's house? And again, let's be clear, this conversation occurred December 24th, 2021.
Okay.
Okay, so we're talking about 3 and a half months before any of this involving Christian McMiller's death or Darius Ford's death or Shamel Drink's death occurs.
Correct.
Okay? Do you take that to be Big's phone? Is there another Big? Do you not know?
There is another Big.
Okay. So, but in any event, Mr. Stillwell is saying he left his phone at someone else's house.
Correct.
Okay. And then D says, finna take it in where you at, indicating that he's taking Mr. Stillwell's phone, right?
I don't take that as taking the phone, like finna take it in, like I'm finna go to sleep or go home.
Fair enough.
Like take it in for the night.
Fair enough. Could you go down, Mr. Atkins? Okay, and this is the part that the state introduced. Okay. He says, if Polka asks, tell her I'm op hunting. Okay, he did not say I'm op hunting.
Correct.
He said, if Polka asks, tell her I'm op hunting.
Correct.
Okay, and Polka you know to be who?
Taisha Alexander.
And that is Mr. Stillwell's girlfriend at the time.
I guess, yes, I don't know. Yes,
Something
at the time,
like
sometimes, yes.
And you also know from your review of the calls that Mr. Stillwell was having some issues with fidelity.
Yes.
Okay. So he's just saying, if Polka asks, tell her I'm op hunting.
Correct.
All right. Thank you, Mr. Atkins. Mr. Atkins, can we go back to that call? I think I finally got my stuff together here. Okay. Remember that call that we were just talking about with, and just to review, it's Garlington and Mr. Stillwell, and they were talking about people were going to assume things, and they're just saying it because they saw us at the gas station.
Correct.
Okay. I want to play, Mr. Atkins, if you could start playing it. I guess we could start at 11:28. Yeah, 11:45. Yeah, that's fine.
Yo, folk.
Yeah. I was there with him yesterday.
Yeah.
Yeah, he got out of town now. So he's gonna get ready to come back. I was just gonna lie with his ass.
Yeah. You ain't talked all night. That whole night crazy, bro.
Yeah, I just talked to her today. I talked to her today.
Man, that be crazy.
I was telling her, I'm like, he on the cell phone, like, he probably be over there, like, what not? She's like, what? You don't think you gonna tell on me? I'm like, man, hell nah.
She crazy. I don't even be texting that back no more.
I should be texting on, like, on the tablet and shit.
Yeah, I don't even be responding to her. That crazy.
Yeah.
Hey, look, I'm finna get bro back his phone, right? I'm gonna get up with you though.
I do that, man. I got you.
Love you. All right.
I love you too.
All right.
All right. Well, okay. Let me just ask you this, and we're going to get it together, and we're going to get it played. Do you remember on that call, that same call, that unrecorded call? I mean, that these two gentlemen thought that they were talking to themselves without being recorded. Do you remember Mr. Stillwell saying, when they test for gunpowder, it's going to come back clean?
I do.
Okay, and that's on this call.
Correct.
All right. And he does not say the car has been cleaned.
Correct.
He's saying, don't worry about it, because when they test for gunpowder, it's going to come back clean.
Correct.
Okay. And that was on the private call between Mr. Stillwell and Mr. Garlington that they had no reason to believe was being recorded.
Correct.
Okay, I'm going to go back to the phone. You made note of 227 VVB11, and we don't need to display it, but it was basically something in Mr. Stillwell's notes that said, "Pop my shit. I really got options. Poor little ops. They be dropping."
Correct.
Okay, and that was in March 15th, 2022 at 12:52 a.m. The phone says that that's when it was entered.
It might say either modified or entered, yes.
Okay, and that was, and we're going to get to it, but you're aware that Mr. Stillwell's grandmother, Betty Jackson, texted him about the shooting, about seeing it on the news that night?
Objection, assuming facts not.
Well, it's going to be in evidence. I'm asking if she's aware. You're aware of that?
I was aware that Miss Alexander notified him about a shooting in Mechanicsville. I don't know if Miss Jackson did.
Okay. It was hours, this would have been hours after Miss Alexander alerted him as well, correct?
Okay.
Correct?
I'd have to see it. I'm not.
Okay. All right, well, we'll get to it. But this was at 12:52 a.m.,
Okay.
right?
I haven't seen it, so I just.
Okay, and we've already discussed ops,
Correct.
dropping ops. Those are common themes, common topics of drill music, correct?
Correct.
Okay. And at the time, your investigation, at the time that he entered this note into his phone, he was in fact at the studio, correct? At 12:52 a.m. on March 15th.
After leaving the gas station, they went to a studio. I did not have location data on Mr. Stillwell to say, but I believe they should have still been at the studio.
Still been at the studio creating music when he entered that note.
Creating music, hanging out. Like, yeah, that's what they do. Hang out at the
Okay.
studio.
All right, cool. And then you talked about search words, a search that you noted about a Windsor Street shooting, right? That was in Mr. Stillwell's phone.
So he didn't, and I clarified that on direct. He didn't search Windsor Street. He searched Fox 5.
Okay.
And then
Well-
clicked on, and then within Fox 5, then searched the Fox 5 website.
I appreciate that. So on 3/17 at 2 in the morning, Mr. Stillwell clicked on the Fox 5 website to this article.
Correct.
Okay. Didn't search, your testimony, he didn't search words like Windsor Street or anything, but he clicked on the article and that's what shows up in the phone.
I'd have to see the screen. I believe he searched Fox 5, traveled to the Fox, like say I open my phone and I want to go to Amazon. I search Amazon, click on Amazon, and then on Amazon, I would then search. That's what happened. So he searched for Fox 5, went to Fox 5, then went on Fox 5, I believe searched Windsor Street shooting, and then clicked on the article, is what it looks like.
Okay. And Ms. Knight, could you just display 227 VVA8 so everyone knows what we're talking about? Okay, so this is what you're talking about, right? The search.
Correct.
Okay, that's and this is 3:17 at 2:31 and 56 seconds in the morning, correct?
Correct.
No, that's fine. I want to show you some documents, investigator.
Sure.
It's okay with you. May I approach, Your Honor?
Yes.
Investigator Viverito, I am approaching you with what's been marked 57A, DS57A, DS57C, and DS58. Could you look at these and tell me if you recognize?
Sure. Okay, these are excerpts from Mr. Jackson's phone.
Right, and those are, and are those excerpts from, are those conversations from the data that was downloaded from Mr. Jackson's phone?
Sure, the first one is the one that I spoke about that I had seen of Miss Alexander informing him about the shooting.
It's not admitted yet.
Oh, sorry, yeah.
Are those accurate representations of the data that was in Mr. Stillwell's phone?
Yes.
Okay. Your Honor, at this point, I would move to admit DS57A, DS57C, and DS58 into evidence.
A, C, and E. Say that again, please, if you don't mind.
And there is no DS57B. It's DS57A, DS57C, and DS58.
Oh, okay. Don't know where the E came from. Okay. Those are admitted.
Mr. Kokomo, could you please, permission to publish, Your Honor.
You may.
Mr. Kokomo, could you please publish 57A first? So in this, in DS57A, investigator, this is a conversation between Taisha Alexander, also known as Polka, correct?
Correct.
And Mr. Stillwell.
Correct.
Okay. At 3:14:22, at 11:01 p.m., Miss Alexander reaches out to, or texts Mr. Stillwell and says, "You okay? Somebody just got killed in the Ville. Ugh." Or, ugh. Atlanta, too much right now, right?
Correct.
All right, and then they respond to each other with kisses. Mr. Stillwell asks who got killed, correct?
Correct.
And then Miss Alexander eventually says, "I don't know yet," but before that, she sends some sort of screen message, correct?
Correct.
Okay, and that's the message is sent at 11:19:47 p.m., correct?
Correct.
All right, and Mr. Kokomo, if you could publish 57C. And this is the screenshot that, or the picture that Miss Alexander sent to Mr. Stillwell at 11:19 p.m., correct?
Correct.
And it's a photo, and is that Windsor Street?
I believe so.
And it's captioned, "Somebody just got killed in Mechanicsville."
Correct.
And it's posted by someone named Bori Billions.
Correct.
And whenever Miss Alexander sent this picture or downloaded it, it already had 2,000 views, correct?
Correct.
All right. So by that night, just based on what we see in this phone, by that night at 11 o'clock or 11:15 or 19, the word had spread about a shooting, correct?
Correct.
In Mechanicsville,
Correct.
where someone was killed.
Correct.
Okay. And this was not a secret. It was being spread throughout social media.
Correct.
All right. Mr. Kokomo, if you could post DS58. this is a conversation, and I'm sorry, it's marked 58A, so, Your Honor, if we could just amend that to make 58A.
Sure.
Thank you. So, looking at DS 58A, this is a conversation between Mr. Stillwell and Boss Lady, correct?
Correct.
And you know Boss Lady to be Betty Jackson, correct?
Correct.
His grandmother.
Correct.
His grandmother who raised him.
Correct.
At 11, Mr. Skokomo, thank you. At 11:19 p.m., Shannon texts his grandmother, "I love you."
Correct.
Boss Lady, or Betty Jackson, responds, "Mama love you so much, heart, heart, kiss, 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 'cause you're my sweet thing."
Correct.
And Mr. Stillwell says, "Yeah." I don't know if I'm pronouncing that right, but yeah, right?
Sure.
And then Miss Jackson gives a thumbs up, right? And then at 11:26:57, Miss Jackson says to Mr. Stillwell, or texts Mr. Stillwell, "Hope you are not near Windsor Street shooting on the news," right?
Right.
And then she says, "Answer me, please."
Correct.
And eventually at 11:41, 15 minutes later, Mr. Stillwell responds, "I'm at the studio, Ma."
Correct.
Okay. So, at 11:26, according to this conversation, not only did Miss Alexander alert Mr. Stillwell about the shooting on Windsor Street, but Miss Jackson says there's a shooting on Windsor Street, right?
Correct.
And it's on the news.
Correct.
Was this information about the shooting on the news at that point?
I know that the article that Miss Alexander had, that's a female, I don't know her real name, in Atlanta, that wasn't like an ATL scoop or a news thing. And then I don't know how Miss Jackson saw it, so I'm not sure if you got word of mouth from Miss Alexander, worried about it. I don't
Maybe
know.
she saw it on the news. Maybe
I don't know when the news coverage began.
Okay. The bottom line is, by 11:26 that night, two different people had informed Mr. Stillwell about a shooting, a death, Windsor Street.
Correct.
And the word had spread throughout. It wasn't just Mr. Stillwell that was being informed. The word had spread throughout the Atlanta community that quickly.
Correct.
All right. And basically, the phone indicates on March 17th, 2 days later, Mr. Stillwell clicked on a news article about that shooting.
We sought out the news article and then clicked on it.
Okay.
Yeah.
He sought out and clicked on it.
Correct.
All right. Cool. All right. Right when you started testifying, you remember when you were going through a timeline, and I think it was from 2019 to 2020, different events that had occurred?
I do.
Okay. And we heard a lot of names. Tanquarius Mender, right?
Correct.
And you said he's a member of the Rolling Crips.
As well as YSL, yes.
Okay, and we heard about Stephen Harris.
Correct.
And he's a Crip. And we heard about...
No, I'm sorry, Stephen Harris is a member of YSL.
Okay, he's a member of YSL. We heard about Marcus Sims.
Correct.
He's a Crip.
Yes.
Okay, we heard about Wayne Alford. And we heard about a bunch of other names in this timeline
Correct.
that you were going through. Well, first of all, let me just ask you this. When you were asked about all these events, you were referring to some sort of, you were refreshing your recollection with a sheet that was in front of you.
Correct.
Okay, that was highlighted, color-coded.
Correct.
Okay, did you create that sheet?
Mr. Abadi had created the sheet as a timeline.
Okay, so when you were testifying about those events, you were refreshing your recollection. You were being asked questions by the prosecutors, correct?
Correct.
And then you didn't have any reports of your own with you, did you, about any of these events?
No, I didn't. I was at the GBI at that time, and they were APD cases, so they wouldn't be my reports.
So you didn't investigate any of these events?
So the way it would work is gangs typically doesn't take an aggravated assault or a homicide or things of that nature. We will work with those units and provide them information and assist with their investigations. So the reports, I will help with the cases, but they would fall with those investigators.
Did you have any reports with you when you were of your reports with you when you were discussing those?
No.
Okay. But you were refreshing your recollection off of a sheet of paper that was prepared by the prosecutor.
Well, this is something we had discussed. There's numerous incidents, so we needed a timeline to keep them correct.
All right, well, let me just ask you this. In all those things, 2019, 2020, that you discussed, all those events, Shannon Stillwell wasn't charged with any of those events, was he?
He was not.
Okay, cool. You remember when you talked about how I was asking you about your reports and you said you write them in search warrant applications?
Correct.
All right, I want to talk to you about that. You did a search warrant application for the house of Jeffrey Williams on 355 Allison Drive, correct?
Correct.
All right. Not moving any evidence. I'm going to ask you some questions about that affidavit. Would having your affidavit that you wrote
Sure.
up there with you, would that be helpful?
Sure.
May I approach?
You may.
Okay. These affidavits that you fill out to take to a judge to try to get a search warrant, they're under oath?
Yes.
Okay. A judge relies on them, relies on the accuracy of them, correct?
Correct.
Relies on them to be complete?
Correct.
The intent of an affidavit is not to mislead a judge, is it?
No,
Okay. And you wouldn't mislead a judge, would you?
I would not.
Okay. And you filled out this affidavit on May 9th, 2022, correct?
Following the presentation to the grand jury, yes.
Right. May 9th, 2022?
Correct.
Yeah. And that was also in the wake of these various attacks on Lucci, on Rayshawn Bennett in the jail.
Correct.
Okay. In fact, you were interested. You had that one with Jada Myrick. With Mr. Eppinger and Mr. Sumlin, and Mr. Eppinger was trying to get Mr. Sumlin to talk to someone to get payment, right? And you suspected that person to be Jeffrey Williams.
Suspected, and that was confirmed by Mr. Sumlin.
Okay, so you suspected that to be Jeffrey Williams.
Right, and was confirmed by Mr. Sumlin, yes.
Okay. Again.
Yes,
just
I suspected,
just
yes.
Questions I ask, okay? So you saw a search warrant for Jeffrey Williams' home for evidence on these matters, correct?
No.
Okay. You sought a search warrant for Jeffrey Williams' home.
For his body, for his cellular devices, and for gang evidence.
Okay. Okay. So in Mr. Williams' home.
Correct.
All right. In your affidavit is what's used to develop PC, or probable cause, for the judge to rely on, right?
Correct.
And in your affidavit, I think it's in the 4th page, you reference a post that you saw on the internet about Jeffrey Williams posting, YFN, and this is already in evidence, YFN, if ain't like what you do for your mother and kids, I would have killed you, right?
Correct.
That's referenced in your affidavit.
Which page is not on 4?
Well, mine's not numbered, but I'm just going to go by. Right, it's on the 5th page, I'm sorry. If we count, and again, they're not numbered, but I'm just going by the 5th page that I have.
So,
And it would be the first, it would have been the second full paragraph. So there's one sentence and then 2 paragraphs down.
1, 2, 3, 4, 5.
You can look at my, may I approach?
Yes. Okay, that's different than what I have.
You reference seeing on XXL this magazine, you reference seeing this post that Mr. Williams supposedly made, correct?
Correct.
Okay, and that made your affidavit because you thought that was important to show Mr. Williams and his veiled threats to Mr. Bennett, correct?
Correct.
Okay, cool. Can I have that back? I'm just going to need it.
Sure.
I'll bring it back to you. Now, you also, 2 pages after that, whatever page you have it, I have in the beginning it says details 4.
I'm going to have to see the page because these pages are out of, whatever I have is not the same as yours.
You can have it.
Okay, no, I see that one. Okay, I got you.
All right. Also in your affidavit, you include a text thread between Mr. Wooney Lee and Mr. Williams, correct?
Correct.
And as part of this text thread, you draw the judge's attention to a specific line, correct?
I included that amongst other things in the affidavit, yes?
Well, there's one particular line that you put in a bigger font, and you also circled it, or it's circled, correct?
It's circled, yes.
Okay. And you circled it to draw attention to it, correct?
To what I was referring to, yes.
Yes. And the line that you circled to draw attention to was YSL rule the world, kid, 24M on an N head, correct?
Correct.
Okay. And you wanted to highlight that passage said by Mr. Williams in the text thread, correct?
Correct.
You wanted to highlight that for the judge.
Amongst other posts, yes.
Okay. What was he referring to? Why did you feel it important to highlight 24M on an N's head to the judge?
Well, he's referring to YSL ruling the world
Yeah.
as an organization, and it could be a play on words or a play on things that have happened, saying 24M on a racial expletive head.
Okay, 24M on a racial expletive head. It sounds like Mr. Williams had money on someone's head.
It could be taken that way, yes?
It could be taken that way, and you highlighted it and circled it for the judge, correct?
Correct.
Okay. And you believed that too. You wouldn't have misled the judge about what was being discussed, would you? You believed that to be a threat, didn't you?
I didn't say it was a threat. It's saying that he's willing to, that's how they talk. They'll talk about, they have the ability to put money on people's heads.
Okay. Mr. Kokomo, could you please publish Jeffrey Williams 3 and 4? Is that correct?
Jeffrey Williams 3, as well as Jeffrey Williams 3A.
Okay. Could you please publish Jeffrey Williams 3? Oh, before you do that, in this thread that you highlighted in your affidavit to the judge, this thread between Wooney Lee and Mr. Williams took place on February 7th, 2021?
Correct.
Okay. You just started over, Mr. Kokomo, with volume. All right.
Yes. We can put 24M on the front of your head. Y'all young hoe get in line. Slime rule the world. Believe it. Y'all niggas out this motherfucker spending 24 million on their heads. We can put 24M on the front of your head. Y'all young hoe get in line.
Okay. And could you please publish Jeffrey Williams 3A? You see, what's displayed is Jeffrey Williams 3A?
I do.
Okay, and it's a reaction, Jeffrey Williams reacting after Lil Uzi Vert put a $24 million diamond into his head.
Correct.
Okay. Did you know about Lil Uzi Vert and the $24 million diamond and that reference when you filled out this affidavit?
I did not, but I would still stand by what I put in the affidavit.
Okay, so you're telling me right now, on a sworn statement to a judge with knowledge, that Lil Uzi Vert just got a $24 million diamond put into his head the days before Mr. Williams typed that, you would still put that quote, YSL ruled the world, 24 million on an N head in that affidavit?
Objection. Vague, compounded, maybe mischaracterization of what the witness just said.
Overruled.
I did not have knowledge of Lil Uzi Vert getting a diamond in his head.
Okay, so all right, so let me ask that last question again. Instead of saying I would do it again, if you had knowledge that Lil Uzi Vert just got $24 million diamond in his head and that Mr. Williams was referring to that, would you still have put that in the affidavit?
Yes.
To mislead the judge?
Not misleading. May I explain?
Yes.
Okay. What I'm saying is this social media direct message is different than what you see on here. Lil Uzi Vert, I don't remember, is a member of YSL, so I think it might be a new, like a term they're going to coin. Like wipe his nose, things of that nature. So 24 on somebody's head might be a new thing that they're going to go with. He's saying YSL rules the world. As the leader, he can make that assertion.
You're doing a lot of explaining. Did you do any of that explaining in your sworn affidavit to the judge?
The sworn affidavit reads, Jeffrey Williams brags that YSL rules the world and has $24 million.
Okay. And clearly, when you put highlighted and circled 24M on a N's head, you're sending a message to that judge, are you not? Let's be real.
I'm referring to my words that I wrote say, Jeffrey Williams brags that YSL rules the world and has $24 million.
All right, and just so we're clear, as we sit here today, as someone, a law enforcement officer, even with knowledge of this, you would still put that in front of the judge?
There are different interpretations to everything as we've seen throughout this whole trial.
I agree. Can we make our determinations, or are you going to make the determinations for us?
Objection. Arguments is
Sustained.
Do you think maybe you misinterpreted what was said by Mr. Williams? Is that a possibility?
I think it differs from what was presented on the internet and between direct messages, as we've seen.
So your answer is no, your interpretation is perfect, pristine.
My interpretation was YSL rules the world, and they have $24 million. That's what I wrote in my words in the affidavit. I didn't say Mr. Williams has $24 million on YF and Lucci's head. I didn't say that. I said YSL rules. He claims that YSL rules the world and has $24 million.
Now, you didn't say it. You just put in a bigger font and circled it for the judge, right? Right?
It wasn't a bigger font. That's how the message reads. It's the same font as the date and time, the same size as the date and time as the name, the Instagram handle.
In the circle?
It's circled, correct.
Let's talk about you, Ms. Knight. Could you pull up 227 VV A6B? Thank you, Ms. Knight. Yesterday, you indicated that, now this is from a video.
Correct.
With Mr. Nichols.
Correct.
Rolling a blunt.
Correct.
Okay. And then there's other individuals there, correct? There's other individuals in the room?
Correct.
Okay. And then it's on Mr. Stillwell's phone, so you're presuming that Mr. Stillwell was filming the video?
It was filmed from his device. So
Right,
yes.
right. Okay. So yesterday, you made a claim that a gun, well, what did you say? A gun is, I don't want to jumble your words. What are you claiming about the guns on this table?
A gun is what?
You identified or thought a gun was consistent with something?
It could be consistent with a Glock 27.
Could be consistent.
Correct.
Okay. And which gun is this?
The one towards the back right here.
Okay. Could be consistent with a Glock 27. All right. It could also, well, first of all, are you a firearms expert?
I'm not.
Okay. You're just someone who's owned a Glock before.
Several, yes.
Okay. And before yesterday, had you ever made the claim that, oh, I reviewed this video and this appears to be a Glock 27?
That was my first time testifying yesterday, so where else would I make?
What about reports? Did you ever write a report and said, I reviewed this is very important. I reviewed this video that was in Mr. Stillwell's phone, and I believe that that could be consistent with a Glock 27.
Well, while reviewing the evidence in preparation for trial, when I took a better look at this video and found it, it was probably 2 or 3 days before I testified, and that's when I first had to really research through and look at photos and kind of isolate what kind of gun that was.
So the answer is no, you didn't write a report.
No.
Okay. And certainly the first time saying it to me or anyone on this side was yesterday in court.
Correct.
Okay. You say it looks like it could be consistent with a Glock 27 based on the shape of the bottom of the grip. Is that correct?
Correct.
Okay. It could also be consistent with a Springfield firearm, correct?
I'm not familiar with a Springfield, but from how the magazine looks, also it could be consistent with a Glock.
Okay. It could also be consistent with a Sig Sauer. Could also be consistent with a Smith & Wesson, correct?
I'm familiar with a Glock.
Right, because you're not a firearms expert. You're only familiar with these Glocks.
I never claimed to be, Mr. Sharp.
Okay, well, you start identifying guns in court, Kind of making yourself an expert, but you're not an expert, are you?
I'm not.
Okay. And you don't even know, whatever this gun is, if Mr. Stillwell left with that gun or didn't leave with that gun. You don't know if anyone left with that gun. You don't know whose gun that is.
Correct, but we don't know that they didn't.
Okay. Right. Let me ask you this about your Glock 27 that you say this looks consistent with. When you shoot your Glock 27, does it expel shell casings?
I don't own a Glock 27. When I was purchasing a subcompact Glock, I was going back and forth between the 27 and the 43. I prefer to shoot a 9mm, so I went with the 43.
So you don't even own a Glock 27?
I just said when I was researching the two, handling the two at the gun dealer.
So now you don't own a Glock 27. You were researching it, which means you were handling the gun at the gun dealer. That's your experience with the Glock 27.
I never asserted that I owned one. I've seen one. I've handled one. I can recognize one.
So you've handled one at a gun dealer, and that's what you're basing the identification on?
I've recovered a good bit of guns in my career. I know what they look like.
All right, let me ask you this. Since you know about guns, at least through your career, Glock 27s, when you shoot them, do they expel shell casings?
Yes.
Okay, Glock 27s, when you shoot them, do they make a loud bang?
Yes.
When you shoot a Glock 27, does it create a muzzle flash?
It should. I mean, when you shoot it, like during the day, you wouldn't see it, or sometimes at night you can see it, but...
Okay, and when you shoot a Glock 27, does it emit gunshot residue?
If it's inside of a contained area, yes, it would.
Okay. All right. Remember on Friday you talked about you get to the end of an investigation, something seemed small is huge. And we were talking about the post. All right. Well, there's one thing, surveillance video. You would agree that starts huge and remains huge? Like surveillance video is a pretty important part of a case.
Every investigation is different, but yes.
Okay. You've seen the BP video, correct?
I have.
And you've seen it, Detective Hogan showed it to you?
He did, for the purpose of identifying the individuals, yes.
Right, okay. Have you seen the FedEx surveillance video?
I have.
Okay. I'd like to watch it with you. Is that okay?
Sure.
Mr. Kokomo, if you could cue it up. Okay, before you start, Mr. Kokomo, investigator, when did you first see the FedEx video?
It was after I met with Investigator Hogan in the afternoon of the 16th, so it would have been after that.
Okay. Well, are you aware that, and maybe this will help you answer this question, you're aware that Detective Hogan swore out warrants against my client without ever viewing the FedEx video?
I can't speak to what he did or did not do.
Okay. When did you most recently watch the FedEx video?
Probably maybe like a week ago.
Okay. How many times in total have you watched the FedEx video?
A few times.
Okay. A few times. When you say a few times, how many is it?
I mean, I've watched it a year ago, or a couple years, like 2 years ago. I've watched it.
Okay. Mr. Kokomo, if you could please publish the FedEx video. Okay. Go ahead, Mr. Kokomo. Mr. Kokomo, if you could pause that video right now. Thank you. Investigator Viverito. At this point in video, as we have it paused, you would agree that Mr. Drinks' red Versa is on the left, correct?
Correct.
Okay. You would agree that Mr. Stillwell's rented white Audi with tinted windows
Correct.
is in the middle. And you would agree that Mr. Nichols, actually Miss Lewis, Mr. Nichols' wife, that Ford Fusion is on the right, correct?
Either the right or staggered behind it, yes.
Okay. And according to your investigation, Mr. Drinks is alone in the car.
Yes.
Okay. Mr. Stillwell is in the car with Mr. Garlington per your investigation.
Correct.
And Mr. In the car, the Ford Fusion, we have Mr. Nichols driving,
Correct.
Mr. Boyer,
Correct.
and Mr. Farley.
Correct.
And your theory is that while at this light, Mr. Stillwell shot Mr. Drinks. Correct?
I'm not the homicide investigator, so I'm going along with the evidence that was presented to me by homicide. But yes, that's consistent with what Detective Hogan, his case.
Well, you know, he swore out a warrant for Shannon Stillwell for actually shooting Mr. Drinks.
That's consistent with what Detective Hogan had found.
Okay. In this video, you could see headlights, correct?
Correct.
You could see traffic lights.
You can see tail lights and traffic lights, yes.
And you could see brake lights, correct?
Correct.
All right, awesome. Mr. Kokomo, could you just play the video? And I'm just going to ask you to look at the cars closely.
Mm-hmm.
Okay, pause, Mr. Kokomo, please. All right, so we're paused at 1:02:36 on this video. At this point, Mr. Stillwell in the white Audi is pulled off, correct?
Correct.
Okay, and Mr. Nichols and with Mr. Boyer and Mr. Farley have pulled off.
Correct.
Okay, while they were there at that light with Mr. Drinks, did you observe any muzzle flash on that video?
No, and with this quality of video, I would not expect to see it.
Okay, right. You just see brake lights and traffic lights and headlights, but no muzzle flash. Okay, I got you.
A muzzle flash is much, much, much dimmer than a brake light. Like if you're shooting at night, you're hard pressed to see your own muzzle flash.
Firearms expert again.
I'm telling you, my experience from shooting a firearm, we do take night firing courses.
Okay. So let me ask you this. Gunshot residue. You aware that the headliner from Mr. Stillwell's car, the Audi, was collected and tested for gunshot residue?
I am.
You ever talked to Alexander GBI analyst Alexander Coven about the results that he found?
I have not.
Okay. And you are aware that warrants were taken out certainly before any of those GSR results were in, correct?
Correct.
Let's talk about tint. You've been preparing with the state. You know that the state has said that Mr. Stillwell had tint applied to his windows of that white Audi upon renting it, correct?
Correct.
In violation of the rental agreement, I may add.
Correct.
Okay. And this tint was applied on Flat Shoals Road, according to the district attorneys, at about 6:30 p.m.?
According to them, yes.
Okay. You were able to observe the white Audi on March 16th?
I did not walk. Wasn't that interested in it at that point, so I did not walk. It was very, very dark.
Have you seen the pictures that Miss Antoinette Green took of the white Audi after it was recovered when Mr. Stillwell was arrested?
I have.
Did you see any damage to the tint, specifically the front driver passenger tint on that car?
I did not.
Mr. Kokomo, if you could rewind again. No, actually, you know what? I'm sorry. Keep it here. Keep it here. Just play it. I'm sorry, Mr. Kokomo. Okay. You saw that car speed up behind Mr. Stillwell? Pause it, please. You saw
Yes.
that? Mr. Stillwell, you're aware that he, well, you've already stated this, he was victimized in the past. Someone shot through the rear windows, killing Tiara Jones.
Yes.
And now, that car that sped up is next to Mr. Drinks, correct? Or approaching Mr. Drinks?
It's approaching, but it stopped short of Mr. Drinks.
Okay. Mr. Kokomo, if you could please play it. Okay. So now there's a pause. So now there's one car next to Mr. Drinks, correct?
It's still not next to him. You could see from that angle that it looks like the front of the car. I'm sorry. The front of the car is like, from what I can see, looks like the front of the car. The front wheels are still towards the back of the vehicle. It's not like exact with the car.
Okay. Mr. Kokomo, if you could please play. Pause. See that car make a U-turn?
I do.
Okay. What car was next to Mr. Drinks when that car suddenly made a U-turn?
Judging by how the lights are, that car still appears to be back a little bit, but next to it.
All right, so now you're making three-dimensional evaluations, but we can't see a muzzle flash off this.
A muzzle.
view.
Mr. Sharp, I'm going to explain to you. When you're, I don't know if you're mischaracterizing it. When you go to the range, example, to fire your weapons at night, and there's a line of shooters, it's not bam, 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 lights everywhere. It's a very, very muted, if it shows. So this far away with this quality of video, I would not expect to see that.
Okay, well, let's talk about this car.
Sure.
This car makes a U-turn. Did you see, is there like a train that's crossing that would have let this person know, no, I need to find another route?
No.
Is there a officer saying, hey, turn around, you can't come this way?
No.
Is there an animal crossing the road that would have made this man do a U-turn?
No.
Who is this? Whose car is this that made the U-turn?
I don't know.
Okay. Do you know if anyone ever tried to use these license plate readers to determine whose car that is so we could talk to them about why they made that sudden U-turn?
That would be part of Detective Hogan's investigation, but I do not.
Okay. Could
Was her clothing also collected?
Yes.
And the vegetation that you observed in her hair when she arrived at your facility, was that also collected?
Yes.